Caroline Flack, 40, was facing trial for allegedly assaulting her boyfriend Louis Burton in December 2019 before she tragically took her own life on Saturday. She was due to attend Highbury Corner Magistrates Court in London on March after she pleaded not guilty to assault by beating following an alleged early morning altercation. Her alleged victim and beau Louis had begged authorities to drop the court case and pleaded she was innocent. Following her death, the case will be terminated after death certificate is produced to the court, according to British law. Once formal evidence of death is given, the proceedings will be ended and the Crown Prosecution Service (CPS), who were bringing the charges, will issue discontinuance which ends the litigation. The CPS is likely to inform its witnesses that they are no longer required to attend court. Following Caroline's death, the CPS may have review, at the Director of Public Prosecution's request, to see if they were correct in charging her. This may be carried out by an external body or internally. A review may conclude that previous decision was wrong. Louis may be able to get answers as to why the CPS made their decision to go to court through the CPS Victims' Right to Review scheme. The scheme allows victim to request review of decision to stop or not to bring proceedings. If request is made under the scheme, and the suspect dies between the original decision and the review will still take place. The purpose of the review in these circumstances is to assess whether the original decision was wrong and, if so, to provide an explanation to the victim and offer an apology if needed. When Mirror Online reached out to Highbury Corner Magistrates Court for comment, they had no information on how the court will proceed. Since her death on February 15, it emerged Caroline wasn't taken to hospital when she was given clinical assessment by paramedics at her flat on Valentine's Day. In less than 24 hours, the Strictly Come Dancing winner had killed herself. London Ambulance Service spokesperson confirmed. Crews attended and, following clinical assessment, the person was not taken to hospital. Due to patient confidentiality, we cannot comment further. Broadcast and talent agent Louisa MacDonald released statement criticizing the CPS decision to pursue the high-profile case despite Caroline's vulnerable state. MacDonald wrote, "We are devastated at the loss of our client and friend Caroline Flack, an immensely talented young woman who was at the top of her game professionally and loved by television viewers across the country. In recent months, Caroline had been under huge pressure because of an ongoing case and potential trial which has been well reported. The Crown Prosecution Service pursued this when they knew not only how very vulnerable Caroline was but also that the alleged victim did not support the prosecution and had disputed the CPS version of events. The CPS should look at themselves today and how they pursued show trial that was not only without merit but not in the public interest, and ultimately resulted in significant distress to Caroline. Our thoughts are with Caroline's family at this time." Francis Ridley, Money Talent Management. In response, the CPS said its deepest sympathies go to the family and friends of Flack, but did not comment further. However, on Sunday, the CPS said it had been asked questions about the role of the CPS in deciding whether to charge an individual with criminal offense, adding, "The following information explains our role and approach. It is not comment on any individual case." The CPS said, "We do not decide whether person is guilty of criminal offense that is for the jury, judge or magistrate, but we must make the key decision of whether case should be put before court." It said every charging decision is based on the same two-stage test in the Code for Crown Prosecutors. Does the evidence provide realistic prospect of conviction? That means, having heard the evidence, is court more likely than not to find the defendant guilty? And, is it in the public interest to prosecute? That means asking questions including how serious the offense is, the harm caused to the victim, the impact on communities, and whether prosecution is proportionate response. The information they posted linked to included guidance for prosecutors when considering domestic abuse allegations, gives specific advice on how to proceed when complainant does not want to support prosecution, which can often be feature of these difficult cases. It provides guidance on the information required to understand why complainant may withdraw support and the different options that should be considered, including proceeding without the complainant's support if other evidence is available. It sets out number of factors which may be helpful when considering the public interest in whether to charge in these circumstances. In section of the CPS website with the heading Retractions and Withdrawals by Complainants, it says, "It is possible that complainant may ask the police not to proceed any further with prosecution case and say they no longer wish to give evidence. There may be number of reasons why complainant will withdraw their support from prosecution, or retract their allegation. But this does not mean that the case will be automatically stopped." The website lists possible reasons why complainant may no longer support case. These include fear of other offenses being committed or risk of further harm, fear of coming face to face with the abuser in court, pressure from the perpetrator, fear of repercussions that may follow from peers of the perpetrator, fear of being publicly shamed and wish to be reconciled with the perpetrator. The CPS say reasons such as these should be considered as means to assist prosecutors in understanding how they will need to consider the next steps to be taken.